I never imagined that planning my husband's funeral would become a legal education in disguise. But then again, I never imagined my sister-in-law would try to steal his inheritance by claiming I was too grief-stricken to think clearly. My name is Rachel Thompson, and 3 weeks ago, I lost my husband David to a sudden heart attack at age 45. What I didn't lose was my ability to handle complex legal and financial matters. Though my family seemed to think grief had somehow erased 15 years of legal training, David died on a Thursday. By Friday morning, I was reviewing the will I had helped him draft 2 years earlier. As an estate planning attorney myself, though I'd stepped back from practice when our children were born, I knew exactly what needed to happen. Mrs. Thompson, Attorney Williams said, David was very thorough. Everything goes to you, with provisions for the children's education. Total estate value is approximately $3.2 million, I nodded, my professional mind cataloging next steps while my heart ached. What about probate timeline? 6 months. I forgot you're an attorney yourself. I've maintained my license and continuing education. Old habits die hard. The funeral was Tuesday. David's family flew in his sister Linda from Phoenix, his parents from Michigan. I hadn't seen some of them in years, but grief temporarily reunites families. Linda arrived Monday night with the air of someone taking charge of a crisis. She was 45, 3 years older than David, and had always carried herself with authority she felt her birth order granted her. Rachel, honey, she said, embracing me with theatrical sympathy, you look exhausted. You shouldn't be handling all these arrangements alone. I had everything under control. David and I discussed his wishes years ago. Linda's expression shifted slightly. Well, yes, but surely David would have wanted his family involved in these important decisions. Making funeral arrangements while grieving. That's a lot of pressure for anyone. Something in her tone made my legal instincts twitch. The will reading was Wednesday morning. Linda insisted on attending, along with David's parents. The last will and testament of David Michael Thompson, Attorney Williams, began. The basic provisions were expected, everything to me, with structured trusts for our children's education. But then came the section I had forgotten about. To be absolutely clear, Attorney Williams read, I explicitly exclude my sister Linda Carter from any inheritance. This is not due to lack of love, but recognition that Linda's financial management history makes her unsuitable for managing inherited wealth. Any attempt by Linda to contest this will should be viewed as contrary to my expressed wishes. The silence was deafening. Linda's face went white, then red, then white again. That can't be right, Linda said quietly. David wouldn't write something like that about me. I remembered that conversation now. David had insisted on the exclusion clause after Linda's catering business failed, leaving her with significant debt and damaged family relationships. David told me about some financial difficulties, I said gently. He was concerned about financial difficulties. Linda's voice rose. You mean the business that failed because of circumstances beyond my control? Linda, David's father said quietly, we all remember the money we lost when your business collapsed. Protecting them from his own sister. Linda stood up abruptly. Rachel, this doesn't seem right to you, does it? I looked at her carefully, my attorney instincts now fully alert. Linda, the will is very clear. David and I discussed these provisions thoroughly. When you drafted it, Linda repeated. Rachel, I don't mean to be insensitive, but you're clearly overwhelmed right now. Grief affects people's judgment. Maybe you shouldn't be making major decisions about David's estate until you've had time to process this loss. There it was, the suggestion that grief had somehow impaired my ability to think clearly. From someone with no legal training to someone who had spent 15 years specializing in exactly these types of cases. I appreciate your concern, I said evenly, but I'm perfectly capable of managing David's estate. Your former area of expertise, Linda corrected. Rachel, when did you last handle a probate case? When did you last practice law at all? I maintain my license and continuing education requirements. And this will is straightforward. Linda exchanged glances with David's parents. I just think the family should be involved in major decisions. David's gone, and now you're making choices that affect all of us without any input. The only choice I'm making is to honor David's will exactly as he wrote it. But Rachel, Linda pressed, You have to admit you're not thinking clearly right now. No one would blame you. Grief is overwhelming. But maybe you should let people who aren't emotionally involved help guide these decisions. I felt something shift inside me then. The suggestion that I was emotionally incapable of handling legal matters in my own area of expertise. Regarding my own husband's will was both professionally insulting and personally manipulative. Linda, I said quietly, I understand you're disappointed about David's will. But my grief doesn't affect my ability to read legal documents or understand David's clearly stated wishes. I'm not saying you can't read, Linda said, her voice taking on a condescending tone. I'm saying that massive grief can affect judgment, decision-making, cognitive functions. It's not your fault, but it's reality. See, this is exactly what I'm talking about, Linda continued. You're so convinced you know everything that you're not open to guidance or help. I realized then that Linda wasn't just disappointed about the inheritance. She was systematically questioning my competence while positioning herself as the reasonable family member concerned about my well-being. Have you ever had someone use your grief or vulnerability against you? When someone suggests that emotional pain somehow erases your professional competence, there's something particularly cruel about people who weaponize your moments of greatest vulnerability to advance their own agendas. If you've ever had someone question your judgment during a difficult time when you needed support instead of doubt, you know how isolating and infuriating that experience can be. As we left the attorney's office, Linda walked beside me, her voice gentle but persistent. Rachel, I know this is hard, but I really think you should consider letting the family help with some of these major decisions. David would want his loved ones looking out for you. I looked at her carefully, my legal mind now fully engaged despite my grieving heart. Linda wasn't offering help. She was positioning herself as the family authority while undermining my competence to manage David's estate. What Linda didn't know was that she was trying to manipulate someone who had spent 15 years helping people protect their estates from exactly this type of family pressure. She thought she was dealing with a grief-stricken widow who would be grateful for guidance. She was actually dealing with an estate planning attorney who was about to defend her husband's will with every skill she possessed. David had been right to exclude Linda from his inheritance, and I was about to prove that grief hadn't diminished my ability to understand exactly why. Linda didn't leave town after the funeral. Instead, she extended her stay to help Rachel through this difficult transition. What I didn't realize initially was that she was systematically building a case that I was mentally unfit to manage David's inheritance. It started with small comments disguised as concern. The day after the will reading, I was reviewing insurance policies and financial accounts, standard estate administration tasks. Rachel, you've been staring at those papers for hours, Linda said, bringing me coffee I hadn't asked for. Don't you think you should take a break? All this financial stress can't be good for you right now. It's not stressful, it's necessary. The life insurance company needs these forms within 30 days. But honey, you're trying to handle everything yourself. David's gone. You don't have to prove you can manage alone anymore. I looked up from the paperwork. I'm not trying to prove anything. I'm administering David's estate according to legal requirements. Linda sat down across from me, her expression carefully crafted to show loving concern. Rachel, I've been thinking about what you said yesterday about maintaining your law license. When did you actually last handle a case like this? Every estate is different, but the basic procedures are the same. But when specifically, what was your last actual case? I felt cornered by the question. I've done pro bono work for friends over the years. Estate planning, simple wills, friends' wills, Linda repeated. But a $3.2 million estate with multiple investment accounts, life insurance policies, property transfers. When did you last handle something this complex professionally? The honest answer was 8 years ago. But the procedures hadn't changed, and I was methodically following every required step. The complexity doesn't change the fundamental process, I said. Of course not, Linda agreed quickly. I'm just worried about you taking on so much responsibility when you're grieving. Maybe you should consider hiring someone to help. David would want you to have professional support. That afternoon, David's parents called. The conversation started, normally checking on how I was doing, asking about the children's adjustment. But then the tone shifted. Rachel, David's mother said carefully, Linda mentioned she's concerned about you handling all the estate matters alone. She thinks you might be taking on too much. I'm managing everything fine. It's actually helpful to have clear tasks to focus on. But dear Linda says some of the financial decisions you're making don't seem well considered. She's worried that grief might be affecting your judgment. I felt my professional instincts sharpen. What financial decisions specifically? There was a pause. Well, she mentioned you spent quite a bit on the funeral arrangements. And something about expensive legal fees for estate administration. I almost laughed. The funeral cost $8,000 for everything David wanted. And I haven't hired any attorneys. I'm handling the estate administration myself, because I'm qualified to do so. Of course you are, dear. Linda just thinks maybe you're not seeing the big picture clearly right now. After that call, I started paying closer attention to Linda's comments and behavior. She had positioned herself as the family liaison, calling David's relatives with updates on how I was coping. But her updates seemed designed to create concern rather than provide comfort. I began taking notes. The next morning, Linda was in my kitchen when I came downstairs, talking quietly on her phone. She ended the call quickly when she saw me. Just checking in with Cousin Mike, she said brightly. He's so worried about you managing everything alone. What did you tell him? Just that you're doing your best. But it's a lot for anyone to handle, especially someone who hasn't practiced estate law in years. 8 years. And I've kept current with continuing education requirements. Of course, Linda said. But there's a difference between maintaining a license and actually practicing, isn't there? I mean, would you want a surgeon operating on you if they hadn't been in an OR for 8 years? Even if they had kept their medical license current? The comparison was absurd, but I could see how it might sound reasonable to someone without legal training. That's when I realized Linda was crafting narratives designed to sound logical to family members who couldn't evaluate their accuracy. That afternoon, I called my former colleague Sarah Kim, now a solo practitioner specializing in estate law. Rachel, I was so sorry to hear about David. How are you holding up? As well as can be expected. Sarah, I need to ask you something. I'm administering David's estate myself, and his family is questioning whether I'm current enough with estate law to handle it properly. Are you kidding? You were one of the best estate attorneys in the city before you stepped back. Have you kept up with CLE requirements? Yes, and I've done some pro bono work over the years. But they're suggesting that 8 years away from full-time practice makes me incompetent to handle my own husband's estate. Sarah was quiet for a moment. Rachel, is someone pressuring you to hire outside counsel? Because that sounds like manipulation, not legitimate concern. David's sister is very vocal about her concerns. For my judgment during grief, I see. And does this sister happen to have any financial interest in how the estate is administered? I told Sarah about the will and Linda's exclusion from inheritance. Rachel, listen to me carefully. What you're describing sounds like the beginning of a competency challenge. Someone is building a narrative that you're mentally incapacitated by grief, and therefore unfit to manage the estate. My blood ran cold. She wouldn't actually, she absolutely would. I've seen family members contest wills on exactly these grounds. They claim the surviving spouse is mentally incompetent due to grief, and therefore the estate should be managed by someone else, usually them. That evening, Linda made her move more directly. David's brother Tom had arrived from Denver, and Linda immediately pulled him aside for a private conversation. Later, Tom approached me with obvious discomfort. Rachel, Linda tells me you're insisting on handling all of David's estate matters yourself. She's worried that might not be the best decision right now. Tom, I'm an estate planning attorney. This is literally my profession, but you haven't been practicing recently, right? And Linda says grief can really affect people's judgment, even when they don't realize it. I looked at Tom, David's younger brother, whom I had known for 15 years, and saw doubt in his eyes. Linda had successfully planted seeds of concern about my mental competence. Tom, do I seem mentally incapacitated to you? He looked uncomfortable. No, but well, you might not be the best judge of your own condition right now. That night, I did something I hadn't done since my litigation days. I started building a case file, not for court, but to document what was happening and protect myself from Linda's manipulation campaign. I created a timeline of Linda's comments, her phone calls to family members, and her attempts to position herself as the reasonable family member, concerned about my welfare. Have you ever watched someone systematically undermine your reputation while pretending to care about your welfare? When someone uses your vulnerability as evidence that you can't handle responsibilities, you're actually managing perfectly well. It's a particularly insidious form of manipulation because it disguises attacks as concern, making you look paranoid or unstable if you defend yourself. If you've ever had to prove your competence to people who should have trusted your abilities, you understand how exhausting and infuriating that experience can be. The next morning, Linda escalated her campaign. She had apparently spent the evening calling David's relatives, because by 10 a.m., I received 3 separate calls from family members expressing concern about my handling of estate matters. Rachel, David's aunt, called to say, "Linda thinks you might benefit from some help with the financial decisions. She mentioned you've been making some questionable choices." "What questionable choices specifically?" "Well, she didn't give details, but she's worried about your judgment right now." I realized Linda was being deliberately vague, allowing people to imagine problems rather than having to specify actual mistakes. It was a sophisticated manipulation strategy that would be difficult to counter without seeming defensive. But Linda made one crucial error in her campaign. She assumed I was too grief-stricken to recognize what she was doing. Linda thought she was dealing with a grieving widow who could be easily manipulated and discredited. She was actually dealing with an estate planning attorney who was about to document every aspect of her manipulation campaign and use it to prove exactly why David had excluded her from his inheritance. The campaign to make me appear mentally incompetent was about to become evidence of why Linda herself was unfit to inherit anything from my husband's estate. 2 weeks after David's funeral, I was served with legal papers that took my breath away. Linda had filed a formal petition claiming I was mentally incapacitated by grief and unfit to serve as executor of David's estate. The petition was professionally prepared by an estate litigation attorney. Linda had deliberately not mentioned that I was a licensed estate planning lawyer, describing me only as a housewife who stepped back from work years ago. Petitioner submits that Rachel Thompson has demonstrated impaired judgment and decision-making capacity that renders her unfit to manage a complex estate valued at $2 million. Every reasonable action was reframed as evidence of mental impairment. My professional competence was portrayed as stubborn independence. My methodical estate administration was characterized as obsessive behavior, excluding family involvement. The most revealing allegation: Mrs. Thompson has repeatedly claimed legal expertise she has not actively maintained, suggesting grandiose self-assessment consistent with grief-induced cognitive impairment. Linda was arguing that my confidence in my professional abilities was evidence of mental illness. I called Michael Rodriguez, a probate litigation attorney I'd worked with years earlier. "This is a hatchet job," Mike said after I read him the allegations. "She's arguing that grief makes you too crazy to manage money, and your legal training makes you too arrogant to accept help. Is it winnable for her? Not if we demonstrate you're handling the estate competently, and her real motivation is financial gain. But this will be ugly. What does she have to prove? Legal incapacity requires evidence that grief has actually impaired your cognitive function, affecting property management decisions. And what do I need to prove? That you're competent, managing the estate properly. And her challenge is motivated by financial interest, rather than concern for your welfare." That evening, I gathered every estate administration document, insurance forms filed correctly, investment transfers processed efficiently, all legal requirements met precisely. I also compiled evidence of continued legal competence, continuing education certificates, recent pro bono cases, correspondence showing sophisticated legal analysis. Most importantly, I documented Linda's true motivations. Her catering business had collapsed spectacularly, leaving her with $180,000 in debt. Her divorce settlement was minimal because assets were tied up in the failed business. Linda needed money desperately. David's $3.2 million estate represented her solution. My former colleague, Dr. Sarah Kim, called after hearing about the challenge. "This is outrageous. You've consulted with me on estate matters just 6 months ago. You helped the Hendersons with their trust revision last year. Would you be willing to testify to that?" "Absolutely. You're handling this more professionally than many full-time practitioners. Linda's attorney subpoenaed records of every financial decision I'd made since David's death. Looking for evidence of poor judgment, they found none. Every insurance claim filed properly. Every account transfer executed according to legal requirements. Every expenditure reasonable and well documented. During my deposition, Linda's attorney focused on emotional questions designed to demonstrate grief was affecting my judgment. You've been handling these matters alone, without professional assistance. Doesn't that suggest you're not thinking clearly about your limitations? I am a professional with 15 years of estate planning experience. Handling my husband's estate myself is appropriate and cost-effective. You haven't practiced full-time in 8 years. Isn't it possible you're overestimating your current competence? Is it your position that maintaining a law license, completing continuing education, and handling estate planning on a consulting basis for 8 years somehow erases 15 years of professional training? He shifted tactics. Your family has expressed concern about your judgment. My husband explicitly excluded his sister from inheritance due to her financial management history. Their concerns seem motivated by financial interest rather than my welfare. Then Linda's attorney made a crucial error. Don't you think your husband's exclusion of his sister was harsh? Doesn't that suggest he might not have been thinking clearly when he drafted his will? I smiled for the first time during the deposition. Are you arguing that my husband was mentally incompetent when he drafted his will? Because that would invalidate the entire document, including provisions that benefit me? The attorney realized his mistake immediately. If David was incompetent when he wrote the will, the entire will was invalid. But if David was competent, then his explicit exclusion of Linda was legally binding and clearly intentional. Have you ever watched someone's legal strategy collapse in real time? When someone makes an argument that accidentally destroys their own case, there's particular satisfaction in watching skilled manipulation meet legal expertise and lose. If you've ever had to defend your professional competence against people who underestimated your abilities, you know how empowering it feels when their attacks prove exactly why. The competency hearing was scheduled for a Thursday morning in Judge Patricia Williams' courtroom. I had appeared before Judge Williams several times during my active practice years, and she had a reputation for cutting through manipulation to focus on facts and law. Linda arrived with her attorney and 3 family members as witnesses: David's brother Tom, his cousin Mark, and his Aunt Margaret. They were prepared to testify about their concerns regarding my mental state. What they weren't prepared for was discovering who I really was professionally. Your Honor, Linda's attorney began, we're here because Mrs. Thompson, while undoubtedly grieving, has demonstrated a pattern of behavior suggesting she lacks mental capacity to responsibly manage a $3.2 million estate. Judge Williams looked at the file. Mr. Stevens, I see that Mrs. Thompson is representing herself. Before you proceed, I should note that I've reviewed Mrs. Thompson's bar record. She's a licensed attorney in this state with 15 years of experience in estate planning law. I watched Linda's face go pale. She had clearly not researched my professional background thoroughly. Furthermore, Judge Williams continued, Mrs. Thompson has maintained active bar membership and continuing education requirements throughout the period in question. She is professionally qualified to represent herself in this matter. Linda's attorney scrambled to adjust. Your Honor, while Mrs. Thompson may technically maintain a law license, she has not actively practiced estate law for 8 years. Mr. Stevens, I stood up. May I address the court? Mrs. Thompson, you may, Your Honor. I'd like to present evidence of my continued active engagement with estate planning law. I handed the judge documentation of continuing education, correspondence with attorneys on complex matters, and pro bono cases I'd handled. As the court can see, I completed 42 hours of estate planning continuing education over the past 3 years, more than the minimum requirement. I've consulted on estate planning matters, handled pro bono wills and trusts, and maintained active membership in the State Bar's estate planning section. Judge Williams reviewed the documents. Mrs. Thompson, it appears you've been more active in estate planning law during your hiatus than many full-time practitioners. Yes, Your Honor. Additionally, I'd like to present evidence of my administration of my husband's estate to date. I presented a comprehensive file showing every action I'd taken, insurance claims filed within required timeframes, investment accounts transferred according to legal procedures, all probate requirements met precisely. The petitioner argues that I lack capacity to manage this estate. The evidence shows I've managed it more competently than many professional administrators handle similar cases. Linda's attorney tried to redirect, Your Honor. Our concern isn't Mrs. Thompson's technical competence, but rather her emotional state affecting her judgment. Family members will testify that she's become isolated, defensive, and unwilling to consider input. Mr. Stevens, I said, I'd like to address the petitioner's motivations for this challenge. Proceed. Your Honor, the petitioner claims concern for my welfare, but evidence suggests her true motivation is financial gain. I presented documentation of Linda's debt, failed business, and financial desperation. Furthermore, the decedent explicitly excluded the petitioner from inheritance due to her financial management history. This exclusion was not accidental, it was carefully considered and clearly stated. I handed the judge David's will with the exclusion clause highlighted. The petitioner is essentially arguing that the decedent's explicit wishes should be overturned because his widow is too grief-stricken to honor them. This is not a competency issue. It's an attempt to contest a will through the back door. Judge Williams addressed Linda's attorney. Mr. Stevens, I'm going to hear from these family members now, but I want to be clear that I'm evaluating whether Mrs. Thompson lacks mental capacity to manage this estate, not whether her decisions align with family preferences. Tom was called first. During cross-examination, I took a different approach. Tom, in your opinion, should I have filed David's life insurance claims? Well, yes, of course. Should I have transferred his investment accounts according to the will? Yes. Tom, you've described my behavior as focused on legal stuff and rigid about following procedures. Are you saying I should have been less focused on legal requirements? No. I mean, you should follow the law. You said I won't discuss decisions with the family. Tom, which of my legal decisions do you think required family input, rather than adherence to David's will and state law? I don't know. I'm not a lawyer. Do you have any evidence that I've made incorrect legal decisions or managed the estate incompetently? No. When Linda took the stand, I had been waiting for this moment. Linda, you've testified about concern for my mental capacity. Are you familiar with estate planning law? Not specifically, but I understand financial management. Linda, your catering business failed owing $180,000 to investors and creditors, correct? That was due to circumstances beyond my control. Given your own financial management history, why do you believe you're qualified to evaluate my competence in estate administration? I just think David's family should be involved in decisions about his estate. Linda, David explicitly excluded you from his inheritance. Are you arguing that David was mentally incompetent when he wrote his will? No, but so David was competent when he excluded you from inheritance, based on your financial management history. Yes, and he specifically stated that any attempt by you to contest his will should be viewed as contrary to his express wishes. Yes, so you're asking this court to override the explicit wishes of a man you acknowledge was mentally competent when he made those wishes. Linda was trapped. After all, testimony was complete. Judge Williams addressed the court. I've heard testimony alleging that Mrs. Thompson lacks mental capacity to manage her husband's estate. I've seen no credible evidence supporting this allegation. The judge looked directly at Linda. What I have seen is evidence that Mrs. Thompson has managed this estate with exceptional competence and professional skill. Her administration has been methodical, legally compliant, and efficient. I've also seen evidence that the petitioner has significant financial motivations for this challenge, despite claiming concern for Mrs. Thompson's welfare. The courtroom was silent. The petition for determination of incapacity is denied. Mrs. Thompson will continue as executor of her husband's estate. Furthermore, given the apparent lack of merit in this challenge, I'm ordering the petitioner to pay Mrs. Thompson's legal costs. Have you ever experienced that moment when justice actually prevails? When someone who tried to exploit your vulnerability gets held accountable for their manipulation? There's a particular kind of satisfaction when the system works exactly as it should, protecting the competent from those who would take advantage of their grief. If you've ever had to prove your worth in court against people who underestimated you, You know how vindicating it feels when your preparation and expertise speak louder than their assumptions. After the hearing, Linda's family members approached me in the hallway, looking embarrassed. "Rachel, I had no idea about your legal background," Tom said. "Linda made it sound like you were just struggling to cope. Linda told us you were making poor decisions and needed family help," Margaret added. "She never mentioned that you're an attorney or that David explicitly excluded her." As we left the courthouse, Linda walked past me without making eye contact. Her attorney looked frustrated. He had clearly not been given complete information about either my professional background or David's explicit intentions. The woman who had been dismissed as too grief-stricken to think clearly had just outmaneuvered an estate litigation attorney while representing herself in court. Linda had underestimated a grieving widow. She had actually challenged a competent attorney who was protecting her husband's legacy with every skill she possessed. The competency hearing had been a complete victory, but Linda wasn't finished. Within days of the court's ruling, I learned she was planning to appeal the decision and had begun reaching out to David's professional colleagues, trying to find someone who would support her narrative that I was unfit to manage his estate. What Linda didn't anticipate was that David's professional network included people who knew me as an attorney, not just as his wife, Dr. Patricia Adams, David's physician and longtime friend, called first. "Rachel, I heard about the court case. Linda contacted me asking if I had concerns about your mental state following David's death. I told her that you've been handling your grief with remarkable strength and that I've seen no signs of impaired judgment. Thank you, Patricia. But there's something else." Linda seemed surprised when I mentioned your legal background. She didn't seem to know you're an attorney. I was beginning to understand that Linda had built her entire strategy on assumptions about who I was, without bothering to research my actual qualifications. James Mitchell, David's business partner, called next. "Rachel, I got a strange call from David's sister, asking about his business assets and whether I thought you were competent to handle the estate administration. I told her that you've been incredibly thorough and professional in every interaction we've had. But it was the call from Sarah Chen, David's former colleague, that revealed the extent of Linda's desperation. Rachel, David's sister contacted me with very strange questions. She wanted to know if I thought David had been mentally unstable before his death, if his will might not reflect his true wishes. She's questioning David's mental competence." "Exactly." When I told her that David seemed perfectly rational right up until his death, she asked if I thought he might have been unduly influenced by someone close to him. I realized Linda was now pursuing multiple legal theories, that I was incompetent to execute David's will, that David was incompetent when he wrote it, or that I had unduly influenced him. She was arguing that anyone except her was mentally compromised. I received an unexpected call from Judge Williams' clerk, "Mrs. Thompson. The judge wanted me to inform you that Linda Carter's attorney has filed a motion requesting reconsideration of the competency ruling. Additionally, they filed a separate petition alleging undue influence in the creation of your husband's will." Linda was escalating from a competency challenge to a full-scale will contest, but she was making crucial strategic errors. I called Mike Rodriguez immediately. "Mike, Linda is now claiming I manipulated David into excluding her from his will. That's a much harder case for her to make. Undue influence requires proving that you isolated David from family, controlled his decision-making, and benefited from provisions that were contrary to his natural inclinations. But David's exclusion of Linda was based on her financial problems, which were well documented and known to the family." "Exactly. And the exclusion clause specifically references her financial management history." The next week brought professional validation that Linda clearly hadn't expected. David's estate planning attorney called to offer his testimony about David's mental state and clear intentions when the will was created. "Rachel, David was absolutely clear about wanting to exclude Linda. He brought up her business failures without any prompting from you. In fact, you tried to discourage him from including the exclusion clause. But the most serious error came when Linda tried to involve our children in her legal strategy. My daughter Emma called me after school in tears. "Mom, Aunt Linda came to my school during lunch. She said she needed to talk to me about Dad's will, and about whether you've been making good decisions since he died." I felt protective fury. "What did you tell her?" "I told her she should talk to you directly, But Mom, she asked if you've been acting strange, if you think Dad really wanted her to have no inheritance at all. Did she ask you to say anything specific about my behavior? She wanted me to tell the court that you've been acting differently since Dad died. She said it would help make sure you get the support you need. I filed a motion with the court documenting Linda's attempt to involve my minor child and requesting an order prohibiting further contact. Judge Williams was not pleased. During the emergency hearing, she addressed Linda directly. Ms. Carter, did you contact Mrs. Thompson's minor daughter at her school to discuss this legal proceeding? Linda looked uncomfortable. I just wanted to make sure the children were okay, Ms. Carter. I am issuing an order prohibiting any contact between you and the minor children related to this estate matter. Furthermore, I am referring this matter to the State Bar for review of potential ethical violations. After the hearing, Linda's attorney approached me. Mrs. Thompson, I want you to know that I did not authorize my client to contact your children. This was entirely her initiative. Mr. Stevens, it sounds like your client isn't being entirely forthcoming about her actions or motivations. Mrs. Thompson, would you consider a settlement discussion? This case is becoming increasingly problematic for my client. The next day, I received a call from Attorney Williams, who had helped draft David's will. Rachel, I've been thinking about this case. David didn't just exclude Linda from his will. He specifically anticipated that she might challenge his decision and included language designed to prevent exactly what she's doing now. I remember him insisting on that clause. David told me privately that he was concerned Linda might try to manipulate you during your grief to gain access to his estate. The exclusion clause wasn't just about her financial problems. It was about protecting you from exactly this type of family pressure. I realized the full extent of David's foresight. He had not only protected our family's financial future, but had anticipated Linda's manipulation attempts and provided legal tools to defend against them. Have you ever discovered that someone you loved had protected you in ways you didn't even realize until you needed that protection? When their foresight and care extend beyond their life to shield you from exactly the people and situations they worried about. There's something profoundly moving about realizing that someone anticipated your vulnerabilities and built safeguards around them. If you've ever found evidence that someone who's gone prepared defenses for challenges you didn't see coming, you understand how that kind of love transcends even death itself. Linda had underestimated not just my professional competence, but David's strategic thinking when he planned our estate. Her challenge wasn't just failing it, was proving exactly why David had been right to exclude her, and right to trust me completely with his legacy. The defensive battle was nearly over, but Linda's desperation was about to create consequences she had never anticipated. The final hearing took place 6 weeks after Linda's initial competency challenge. What had started as a simple probate matter had evolved into a comprehensive examination of Linda's motivations, my professional competence, and David's clear intentions. Judge Williams' courtroom was more crowded than expected. David's professional colleagues had come to offer testimony. Family members attended to witness the resolution, and Linda sat with her attorney looking increasingly isolated. We're here today, Judge Williams began, to address Ms. Carter's petition alleging undue influence in the creation of David Thompson's will, as well as her motion for reconsideration of my earlier ruling regarding Mrs. Thompson's competency. Linda's attorney stood first. Your Honor, we maintain that Mrs. Thompson influenced her husband to exclude his sister from inheritance. Contrary to his natural affections and family relationships, Mr. Stevens, the judge replied, I've reviewed the evidence you've submitted. Can you point to specific instances where Mrs. Thompson isolated her husband from his family or controlled his decision-making regarding estate planning? Your Honor, the very fact that David Thompson excluded his sister completely suggests Mr. Stevens. The will includes a specific clause explaining the exclusion based on Ms. Carter's financial management history. Are you arguing that this explanation is false? Not false, Your Honor, but perhaps influenced by Mrs. Thompson's perspective rather than David Thompson's independent judgment. Judge Williams turned to me. Mrs. Thompson, I'd like you to address the court regarding the circumstances under which your husband's will was created. I stood, feeling confident after weeks of preparation. Your Honor, My husband and I met with Attorney Williams to update our estate planning in 2021. David raised the issue of excluding Linda from inheritance without any input from me. In fact, I initially disagreed with his decision because I was concerned about family conflict. I presented contemporaneous notes from our estate planning attorney, documenting David's clear instructions and reasoning. Furthermore, Your Honor, David insisted on including the explicit exclusion clause specifically because he anticipated that Linda might challenge his will after his death. He wanted his intentions to be absolutely clear and legally protected. Attorney Williams took the stand to testify about David's mental state during will creation. Your Honor, David Thompson was adamant about excluding his sister from inheritance. He specifically cited her business failures and the financial losses suffered by family members who had invested in her ventures. Mrs. Thompson actually tried to moderate his position. Did you observe any signs that David Thompson was being unduly influenced by his wife? Quite the opposite, Your Honor. David made these decisions independently and insisted on language that was stronger than what Mrs. Thompson preferred. When Linda took the stand in her own defense, her testimony revealed her desperation and entitlement. Your Honor, David loved his family. I can't believe he would really want me to receive nothing from his estate. We grew up together, we shared childhood memories. Rachel didn't know him the way I did. During cross-examination, I addressed her directly. Ms. Carter, are you arguing that your childhood relationship with David should override his explicit written instructions regarding his estate? I'm saying that David would want his family taken care of. Ms. Carter, David left a $3.2 million estate to his wife and children. Isn't that taking care of his family? But his birth family should be included too. Ms. Carter, you don't inherit from your brother based on what you deserve. You inherit based on what he chose to leave you. And he chose to leave you nothing. Do you accept that was his decision? It was Rachel's decision, Linda said, her voice rising. She turned him against his own family. Ms. Carter, do you have any evidence that I influenced David's decision to exclude you? You must have. David wouldn't have done this on his own. Judge Williams intervened. Ms. Carter, do you have any specific evidence of undue influence, or are you basing your claim solely on your belief that your brother wouldn't have excluded you voluntarily? Linda struggled to answer. I just know David wouldn't have done this on his own. After all, testimony was complete. Judge Williams delivered her final ruling. I've now presided over 2 separate challenges to David Thompson's will and Mrs. Thompson's competency. I've heard no credible evidence supporting either challenge. The judge looked directly at Linda. Ms. Carter, your brother left detailed instructions regarding his estate distribution. He was mentally competent, he received independent legal counsel, and he specifically anticipated and protected against the very challenges you've brought. Furthermore, the evidence shows that Mrs. Thompson has administered this estate with exceptional professional competence. Her grief has not impaired her judgment or decision-making capacity. Both the petition alleging undue influence and the motion for reconsideration of competency are denied. David Thompson's will stands as written. Mrs. Thompson will continue as executor with full authority to complete estate administration. Judge Williams wasn't finished. Ms. Carter, I'm also ordering you to pay Mrs. Thompson's additional legal costs incurred in defending against these frivolous challenges. The court finds that your petitions lacked merit and were motivated by financial gain rather than legitimate legal concerns. After the hearing, Linda left the courthouse without speaking to anyone. Her attorney approached me with obvious embarrassment. Mrs. Thompson, I want to apologize for the extended litigation. My client was not entirely forthcoming about either her motivations or the strength of her case. That afternoon, I received calls from David's family members who had initially supported Linda's challenge. Rachel, I owe you a major apology, Tom said. Linda convinced us that you were struggling and needed family guidance. We had no idea she was trying to steal David's inheritance. David was right to exclude her, David's father said during his call. And he was right to trust you completely. I should have recognized that from the beginning. The most meaningful reconciliation came from David's Aunt Margaret. Rachel, Linda convinced us that you were being cold and unfeeling about David's death, that you were excluding family from important decisions. Now I realize that what we interpreted as coldness was actually professional competence. Linda exploited our concern for you to advance her own financial interests. She used our love for David to manipulate us into supporting her theft of his legacy. That night, I sat in David's study, surrounded by the legal documents that had defined weeks of intense litigation. The estate administration was nearly complete. Linda's challenges had been definitively rejected, and our family's financial future was secure. The real victory was more personal than financial. Linda's challenge had forced me to reclaim and demonstrate professional abilities I had sometimes doubted. The legal community's support had validated not just my competence, but my continued standing as a respected attorney. Most importantly, defending David's will had deepened my understanding of his love and foresight. He had anticipated Linda's manipulation attempts and provided me with legal tools to defend against them. His confidence in my abilities had been absolute, even when my own confidence had wavered. Linda had spent weeks trying to prove that I was mentally incompetent to manage David's estate. Instead, she had proven that David's assessment of her financial judgment and character had been absolutely accurate. The woman who claimed I was too grief-stricken to honor my husband's will had just discovered the cost of challenging an estate planning attorney, who was protecting her husband's legacy with every skill she possessed. 6 months after the final court ruling, I stood before a packed conference room at the State Bar Association's annual estate planning seminar, preparing to deliver a presentation titled, "When Grief Becomes a Weapon, Protecting Clients from Family Manipulation During Estate Administration." Looking out at the audience of attorneys, I saw faces that reminded me of my own journey, professionals who understood that legal competence doesn't disappear during personal crisis. How many of you have had clients whose family members questioned their mental capacity during estate administration? I asked. Nearly half the hands in the room went up. Today, I want to share a case study that illustrates how sophisticated family manipulation can disguise itself as loving concern, and how we can help our clients recognize and defend against these tactics. I told them my story, not just the legal challenge and victory, but the systematic manipulation campaign that had preceded it. How Linda had used my grief as evidence of incapacity, recruited family members through carefully crafted narratives, and positioned herself as the reasonable voice of concern while pursuing financial gain. The most insidious aspect of grief exploitation, I explained, is that it attacks the victim's confidence at their most vulnerable moment. When someone consistently suggests that your emotional pain has impaired your judgment, you begin to doubt your own perceptions and abilities. Dr. Elena Rodriguez, a psychologist who specialized in family dynamics during crisis, approached me after my presentation. "Rachel, your case illustrates something we see frequently. Family members who exploit grief often target the specific competencies that pose the greatest threat to their schemes." Linda didn't question your ability to cook or drive. She questioned your legal and financial judgment, because those were the skills that could expose her manipulation. This led to something I hadn't expected, a new professional focus on helping families navigate estate administration while protecting against manipulation tactics. Over the following months, I began consulting with estate planning attorneys whose clients were facing family pressure during inheritance disputes. My experience defending against Linda's challenge had given me unique insights into both the legal and psychological aspects of these cases. My first consulting case involved Maria Santos, a widow whose adult stepchildren were claiming she was too emotionally unstable to inherit their father's business. "They keep saying I don't understand the complexity of running a company," Maria told me. "But I helped build this business for 20 years. Maria, what specific evidence do they have of your incompetence in business management?" "None. They just keep saying that grief has affected my judgment." Within 2 weeks, we had compiled evidence showing that Maria had managed the business more efficiently during her first month as owner than it had been managed in the previous year. Her stepchildren's claims were contradicted by measurable business improvements. "You don't need to prove you're not grieving," I told Maria. "You need to prove that grief hasn't impaired your professional competence. Those are very different standards." 2 years after David's death, I made a decision that surprised everyone. I returned to active estate planning practice, with a specialized focus on protecting clients from family manipulation during crisis. My law practice became a resource for people facing exactly the type of challenges I had experienced. I helped clients document their competence, recognize manipulation tactics, and defend their rights to manage their own inheritance, according to their deceased spouse's wishes. But perhaps the most meaningful aspect was helping people understand that stepping back from professional life doesn't eliminate professional competence. You didn't lose your intelligence when you became a mother, I would tell them. You didn't lose your analytical abilities when you stepped back from practice. You may need to refresh specific knowledge, but your fundamental competence is still there. 3 years after the court battle with Linda, I received an unexpected letter from Linda herself. Rachel, the letter began, I want to apologize for the pain I caused you during an already difficult time. I convinced myself that David wouldn't have really wanted to exclude me from his inheritance, but I know now that I was wrong. The legal challenge wasn't really about your competence or David's wishes. It was about my own financial desperation and my inability to accept that my poor financial decisions had consequences for my relationships with family members. I hope you can forgive me for using your grief as a weapon against you. You are managing David's estate professionally and competently, and I should have respected both his wishes and your abilities. I wrote back a brief response. Linda, I appreciate your apology. I hope you've found healthier ways to address your financial challenges, and that you've learned to respect other people's autonomy during their most vulnerable moments. 6 months later, I was invited to testify before a state legislative committee, reviewing laws related to competency challenges in estate disputes. The current legal framework, I told the committee, often puts vulnerable people in the position of having to prove their competence, rather than requiring challengers to prove actual incapacity. This creates opportunities for manipulation that can be devastating to families during crisis. The committee's final report included recommendations for stricter standards for competency, challenges, and mandatory penalties for frivolous litigation in estate matters. Here's what I learned from this experience and from working with hundreds of other people facing similar challenges. Our greatest growth often emerges from our most difficult battles. The skills we develop protecting ourselves become tools we can use to protect others. The confidence we build defending our competence becomes confidence we can share with people facing similar attacks. Have you ever discovered that your worst experience became the foundation for your most meaningful work? That being forced to prove your worth to people who should have trusted you revealed strengths you didn't know you possessed? Sometimes the most painful chapters of our lives become the most important chapters in other people's stories. The resilience we build protecting ourselves becomes resilience we can teach others to find in themselves. If this story resonates with you, if you've ever been told you're too emotional to make rational decisions, if you've ever had someone use your vulnerability against you, if you've ever had to prove competence that should have been respected from the beginning, then I want you to know that your experience matters, and your strength is real. Subscribe to this channel for more stories about women who refused to let others define their capabilities during crisis, who discovered that vulnerability doesn't equal incompetence, and who transformed their most difficult experiences into sources of strength for themselves and others. Linda thought she was challenging a grief-stricken widow who would be grateful for family guidance. She was actually challenging an estate planning attorney who was about to prove that professional competence doesn't disappear during personal tragedy. The biggest mistake Linda made wasn't underestimating my legal skills. It was underestimating the power of a woman protecting her husband's legacy and her family's future with every capability she possessed. David had been right to trust me completely with his estate. And now, every day, I help other people understand that they can trust themselves to handle their most important decisions, even during their most vulnerable moments. Because grief doesn't eliminate competence. It just reveals who truly supports us and who is waiting for an opportunity to take advantage of our pain. And once you know the difference, you're prepared to protect yourself and others from people who confuse kindness with weakness and mistake temporary vulnerability for permanent incapacity.